Alex here with part 80 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. And number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to ending chronological order. I'd also like to take this opportunity to remind my viewers that if you're not getting every single update on the My Docket series, it's probably because you are a subscriber, but you are not, or you have not clicked on the bell notifications button. If you click on the bell notifications button, which is right next to the subscribe button, that will send a signal to YouTube's algorithm to not just send you the highlights of the channel, but to send you all of the updates on the channel. And that's pretty much the only way that you can guarantee that you get every single video that's been published to the My Docket series without skipping one. Now, I remember at this point my mindset was pretty gung-ho, and that's because my ex's attorney put together an answer that, in my opinion, went so far out of bounds that I had, and not just out of bounds, but I had plenty to say to counteract all of the allegations that my ex's attorney was raising. I feel like the biggest is going to be the fact that she tried to rely on the ruling of the domestic master when the domestic master found the case to be so low level that she only extended the TPO for 3 months, which is 1/4 of what she could have done. And so I'm sure that's going to be what I lead with going into my reply. And I think the best way we can handle this is to just go straight into what I have filed. Here we have my reply to my ex's answer to my petition for writ of mandamus. This time you can see here that I got the caption correct. I have her listed as the real party in interest. Going straight into the introductory paragraph, I'm identifying myself to the court, and I am indicating that I am replying to my ex's answer to the petition for writ of mandamus that she filed on April 23rd, 2012. So I'm on point there, letting the court know not just the document that I'm responding to, but the specific date that it was filed. Let's see here, memorandum of points and authorities. For my ex mischaracterizes my objective. So my first paragraph here asserts that my true objective is for a writ to direct the government to revoke my ex's fictitious address for violating the law, not to reveal her true address to me as she suggests. Yeah, there is a statute that does say that the Secretary of State can be ordered to disclose the address by a judge. And I kind of get where she's going, and I also get where I'm going with this, but the Supreme Court, for the most part, appears to take this position, my ex's position, that the government should be ordered to turn over a true address, not necessarily to cancel a fictitious address. But in my case, it doesn't really matter. I end up getting both of these things anyway. Later on, after she loses this Supreme Court case, her fictitious address gets canceled. And I also do get the government to turn over her true address to me as well. So, I mean, it's annoying that there's little technical details like that that are involved in this case, but I end up, at least myself individually, I end up getting both of these remedies. My ex appears to spontaneously argue that I am no longer, oh yeah, you know, this is ridiculous. So, throughout the entirety of our child custody case, my ex over and over again brought up that she had a right to know where I resided. And it even comes up in at least 2 of the hearing videos. She's trying to know where I reside. And her attorney asserts then and there that she has a right to know where her child resides when he's in my custody. And here we are in the Supreme Court with her completely changing her mind and stating, well, I guess no, parents don't have a right to know where their child resides, even though she'd been arguing the exact opposite for her client for the past who knows how many years. We're at 2012, I think, at the point of this file. Yes, we are. So that's 3-4 years. And it's just the kind of stuff that irritates people about attorneys. How they will. It's one thing to argue different positions with different clients in different cases. That's one thing. But to have two different positions in the same exact case and to waffle back and forth on those positions in the same case is spectacularly ridiculous. In fact, there's a legal doctrine that doesn't allow it. It's called judicial estoppel. It's also called the estoppel of inconsistent positions. I have a video dedicated to the topic. In that video, it's titled Judicial Estoppel, I think. You'll see exactly how it works and all of the different elements that have to be satisfied for you to be able to invoke judicial estoppel. But it does effectively block an attorney from doing something like this. I'm not sure if I knew anything about judicial estoppel at the time that I filed this reply. Otherwise, I think I would have filed it. But, I mean, it's, yeah. Moving on. Let's see here. The argument that I have no right to know where my ex resides when our son is in her custody would invariably be reciprocal. This would entitle me to change my address and take vacations with my son and conceal him from her. And so this is me just pointing out the absurdity of her attorney's position. Basically, with her saying that parents don't have a right to know where their child resides, we could just both hide our child from each other. We could just both not tell each other where either one lives. It's an insane idea. And sometimes I wonder if they realize how they sound when they put together these briefs. Like, do you ever take a step back and read what you're typing? Because this sounds crazy. You're saying that parents don't have a right to know where the child resides when in the other person's custody. It's the most ridiculous thing I have ever read, not just from one attorney, but from the government's attorney as well. So it's the position of Catherine Burning, a private attorney, and it's the position of Catherine Cortez Masto, Secretary of State, or at the very least, it's the opinion of her deputy, this Solicitor General guy, this Charles Wayne Howell guy. Moving on. Next assertion is that my ex's new evidence was not considered in granting her application. Okay, I already addressed this specific argument in the previous video because I dealt with it when the government brought it up as well. So I'm going to skip over it. If you watched the previous video in the My Docket series, you already know how I take care of this specific argument. My ex attempts to confuse the legislature's tools against domestic violence. Yeah, okay, so with this section, I'm pointing out the fact that there are 3 different ways that the legislature deals with domestic violence in these cases. One of the ways is involving temporary protective orders. The other way is involving the confidential address program. And then the third way is involving the award of custody, the award of physical custody to parents. And all 3 of these different statutory schemes involve different standards of evidence, different burdens of proof. In fact, when it comes to custody awards, it has to be shown by clear and convincing evidence that DV has occurred for you to actually get that type of relief in that context. And if you want to know more about the clear and convincing evidence standard, I've made a video on that topic. Go ahead and take a look. TPOs, it's a completely different standard. It's way easier. You just need to prove by preponderance of the evidence that DV might, maybe in the future, one day occur. So that's a huge gap. And then you've got the confidential address program somewhere there in the middle. So I'm pointing out that my ex's attempts to conflate the statutes and how they come into play when it comes to DV should be disregarded by the Supreme Court, and they ultimately are. Allegations are not evidence. And so here's me pointing out the fact that my ex's attorney brings up all of these allegations that have been raised in the lower court. But none of these allegations have been sustained by either of the 2 judges, the domestic master and the district judge. Neither of these 2 judges sustains any of these allegations. And so it's like, why are you bringing up allegations that you've made that have been just disregarded? And the Supreme Court actually mentions this in their opinion. They mention that neither of the 2 judges has made any of these findings against me. And so it's not just lost on me, it's also lost on the Supreme Court of Nevada. Possession of a firearm is not DV, and that's exactly what I meant to articulate in the previous video. What we're here to determine is whether or not DV has occurred or whether or not DV might occur. That second piece isn't really my piece, that's the piece of the government and my ex's attorney. But possession of a firearm is not DV. It's just not. In fact, we have an entire amendment in the Constitution devoted to possession of firearms by legally or law-abiding citizens. So that takes care of that one. My ex exaggerates the domestic master's findings and ignores the district judge's findings, which is true. And the first thing I point out here is verification of a threat is not DV. Verification of a threat is verification of a threat. The statutes to disqualify somebody of physical custody and the statutes that deal with the confidential address program require DV to have occurred. These statutes are meant for victims. These statutes are not meant for people who are saying, hey, I might be a victim maybe sometime from now. I'm not sure when, probably within the next year. I think it could happen. That's just very, very different. So I'm basically saying that her efforts to disregard what the domestic master is doing and, well, her efforts to disregard what the district judge is doing in response to the domestic master's findings are not lost on me and shouldn't be lost on the Supreme Court, and they're not. They do ultimately notice the fact that the district judge has given me physical custody of a child. And so they are perplexed as to what it is that the government and my ex are so concerned with, because all there are floating around in this case and in the lower case is allegations. Tons and tons of allegations. No findings of fact against me. Not a single one. Moving on, and we have the conclusion. Here I point out quite a few, I don't know what to really, I guess you could call them tangents. I'm kind of bringing up some rhetorical questions, like number one, are parents in fact not really allowed to know where their kids reside? Is that really a thing? Number two, is it in my best or my son's best interest that both of us conceal our addresses from each other just out of spite? Number three, are moms entitled to know where the father resides, but not vice versa? And that's kind of the position that my ex's attorney took, because for the first 3 or 4 years, her client had a right to know where I lived, but now that I'm bringing this case to the Supreme Court, all of a sudden, I don't have a right to know where she lives. So this is a problem. These are problems that I'm bringing to the Supreme Court's attention. I ask a number of questions here, and these questions need answering, and the Supreme Court, thankfully, does answer these questions. The case publishes in 2013, if I remember correctly, so it might be some time before we get to the publication, but we will get there. Affirmation, pretty standard, gone over about 100 of these, and it just indicates to the clerk of the court that I have reviewed this filing and it does not contain the social security number of any person. Rule 5 service, which should be under the rules of appellate procedure, not under the rules of civil procedure, but it doesn't matter because for the most part the rules are identical. There are some differences, I think, and it just indicates that I gave this document to my ex's attorney personally, so I dropped it off at the law office, and that I mailed a copy of it to the Solicitor General that is representing the Secretary of State. Next document, we have the supplementary, let me check if there's exhibits. No exhibits. Next document, we have a supplementary example to my reply to my ex's response. Oh, I kind of remember what happened here. Let's take a look here. I am indicating that the different legal standard between these two different statutes are being improperly merged to pervert justice. What I should have said is that they're being the confusion between the two different statutes is being exploited. It's being taken advantage of by my ex's attorney. And what she's doing is she's conflating the law. She's taking these two laws and mixing them together in a way that was not meant to occur. And she did this in front of the Discovery Commissioner on August 16th, 2012. The Discovery Commissioner presided over a debtor's exam where I, the judgment creditor, examined my ex, the judgment debtor, for her deliberate refusal to pay support for the common minor child. I'm going to talk about this a little bit more when we actually get to one of the filings in the lower court case. I'll explain all of these things. I'll explain what a judgment creditor is, judgment debtor, debtor's exam. I'll explain all that stuff. Anyway, she brought up the fact that she was a victim. And what she did was she showed the Discovery Commissioner the confidential address program's confidential address. And the Discovery Commissioner, having no clue how any of this stuff works, because this guy deals with discovery, he doesn't deal with child custody issues, he doesn't deal with the confidential address program, protective orders, he was duped. And he stated this in his order. Respondent was also permitted to provide petitioner with the fictitious address under Nevada's confidential address program, which requires specific evidence showing that the adult child, blah, 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 has been a victim of DV. So the Discovery Commissioner has been duped into thinking that DV has actually occurred because he noticed, number one, she has this fictitious address, and number two, this is how the law works. So logically, he thinks if she has this confidential address, then she must be an actual victim of DV. And that is how attorneys do it. They will take these different statutes and they will dupe other judges, other attorneys into thinking that a certain thing has actually occurred when it hasn't, by using logic, but by not showing or not indicating to that particular person that something like this is unclear or that there's contradictions in the statutes, any of this stuff. And this is something that I wanted to point out to the Supreme Court of Nevada. I wanted to tell them, you guys, look at what's going on here. Somebody is taking a temporary protective order based on a possibility of DV, and then they're taking that, and then they're getting a confidential address, and then they're getting the confidential address, and they're giving it to all these other people, and they're saying, look, since I have this, I'm a victim. See, look at this law. And unless they look really closely, unless they look very carefully at it, they're not going to understand. They're just going to be suckered into thinking it's true. Moving on, this demonstrates precisely how the court can make the leap from presuming the applicant of a TPO at one point demonstrated that there was actually a threat to having demonstrated specific evidence showing that a person has been a victim. And that's what my ex's attorney has done for her. Had my ex merely brought up the point that she at one point had a protective order, the commissioner would have assumed that there was at one point a possible threat of DV. Instead, she exploited her confidential address and thus duped him into thinking that she at one point must have shown she must have shown with specific evidence she was an actual victim to get that. That's what this guy's gonna think. This guy has no clue who we are. He's gonna think, at some point she must have shown some actual evidence that she had this. No, she didn't. And that's something that the Supreme Court will take care of, but it's disappointing to see this is something that people can get away with if you don't take them to task all the way to the highest possible court. And we have a certificate of service indicating that I am serving this document on both my ex and the government. And then we have a list of exhibits. And this is the report and recommendation for order, which I don't think we've gone over yet, but I want to go over it when we actually get to it in the lower court case. I'm going to hold off for now. We will eventually get to this report and recommendation for order in the My Docket series when we get back into the lower court case, when we get back out of the Supreme Court stuff. And at that point, I'm going to spend a lot of time going over what this is. And then, of course, Exhibit 1. Here we have a notice of change of address where I am letting the Supreme Court of Nevada know that I have moved, and I'm not going to spend a lot of time talking about this because I've gone over it a number of times and I have a video specifically dedicated to the topic. You cannot underestimate the importance of filing this. If you are not an attorney especially, go and watch the video, notice of change of address if you've not seen it yet. Certificate of service indicating I served this document upon my ex's attorney and the government's lawyer. Going into the aftermath, I have filed 3 documents, but they were all free filings, so I incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. The government's lawyer didn't file any of these documents, so they incurred $0 in costs. They would have reviewed my reply, but they would have just glazed over it very briefly. In fact, they would have probably spent just as much time putting my change of address into their computer system as they would have reviewing these filings. And so I'm going to put their attorney fees at 15 minutes, which comes to $62.50. My ex's attorney didn't file any of these documents, so she incurred $0 in costs. She would have reviewed the documents probably with the same amount of attention and urgency as the government's lawyer, and so therefore I think it's pretty fair to just say 15 minutes for my ex's attorney as well, which would come to $62.50 in attorney fees for my ex. If you have any questions, feel free to post them down in the comments below, and I will see you guys next time.